अस्सलाम वालेकुम सर। सर मैं दिल्ली आ रहा हूँ।
अच्छा अच्छा,
जी सर।
गुड। वसीम साहब, आप
जी
अपना
सर,
वीडियो
जी सर।
आप अपना वीडियो खोलें।
अच्छा अच्छा।
जी जी।
जी सर।
Assalamu alaikum and good afternoon, all of you. Today, I'm happy to introduce Professor as a senior and eminent and very famous and busiest professor of this university. Rather to say, he, Professor Wasim Sahab is the busiest personality and busiest professor because he is dispensing his valuable service as Proctor of Aligarh Muslim University for, I think, for uh, 5 or 6 years. And Alhamdulillah, university is running within the prescribed discipline, Alhamdulillah, and he is able to face any challenge and he is expert to deal with the crisis management. So we are very happy. But despite of all his engagements in university and to maintain the law and order, Professor Wasim Ali Saab spared his time and quality time, because this time is I think is allocated for the monitoring and governance and administrative setup for the Proctor office. But despite of all these things, Professor Wasim Saab has spared his valuable and precious time for us. And Professor Wasim Sahab, he is the professor of law. And previously, I am disclosing, Wasim Bhai, I am disclosing this. Professor Wasim Sahab was earlier selected as PCS, but he has refused to join, and he joined his alma mater, Aligarh Muslim University, as lecturer, then associate professor, then professor. Now, within the 32 years of teaching career, he has brought laurel to this alma mater, and he has written more than 50 research papers and books, and he attended various orientation program, orientation lecture. And now he is a professor of law in Aligarh Muslim University, and uh, he is also looking after the very, very important responsibility as Proctor of Aligarh Muslim University. And we just before he was mentioning that he has not missed even a single class despite of having such hectic responsibility. So he will speak on some topics related to the law and constitutions. So, sir, I am very thankful to you for sparing your precious time, and I want to brief you that our participants are from Afsha. आप अपना वीडियो बंद कर लीजिए, प्लीज. सो मैं वीडियो इसलिए बंद कराता हूं कि थोड़ी सी उसके अंदर वो सिग्नल्स के अंदर फिर प्रॉब्लम होनी, स्पीड प्रॉब्लम होने लगती है. तो वसीम भाई, आप वसीम साहब हमारे बहुत सीनियर हैं और हम मेरे ऊपर खास तौर पे बहुत शफीक हैं और बहुत ही, तो मैं आपसे को ये बताना चाहता हूं कि हमारे जो पार्टिसिपेंट्स हैं इस पूरे एनईपी के इस ओरिएंटेशन प्रोग्राम को कामयाब करने में उन लोगों का बहुत बड़ा हाथ इस माना कर रहा है कि अटेंडेंस बहुत अच्छी रहती है, प्लस ये लोग बहुत ध्यान से सुनते हैं और बहुत ही अच्छी तरीके से एक्नॉलेज करते हैं जो है वो हमारे रिसोर्स पर्सन को. तो मुझे उम्मीद है कि और हर जबान में गुफ्तगू रहती है, बहुत इंटरेक्टिव सेशन रहता है. कोई ऐसा नहीं है कि रिसोर्स पर्सन खाली, रिसोर्स पर्सन भी बीच बीच में सवाल पूछते हैं, ये भी बात गुफ्तगू रहती है. तो मैं आपका HRDC की तरफ से और अपनी जानिब से और अपने पार्टिसिपेंट्स की जानिब से आपका बहुत खैर मकदम करता हूं और आपका शुक्रिया अदा करता हूं कि आप तशरीफ लाए, और आपसे गुजारिश करता हूं कि आप अपना लेक्चर की शुरुआत फरमाएं.
Thank you very much, Dr. Ahmed Mustafa Saab, for inviting me in this event that has been organized by the HRD Center for the orientation of the teachers from the different universities, colleges. As you have already introduced that I have been teaching law for last uh, more than 25 to 30 years. Uh, at the same time, I'm also discharging some administrative responsibilities. But after all, we all are teachers, and being a teacher, we have certain responsibilities, and the basic responsibility is to go to the classroom, deliver in the classroom, and not only to deliver in the classroom, but to deliver. Rather, every teacher is supposed to deliver in the classroom to the maximum satisfaction of the stakeholder, that is the students. Because that is the main responsibility or main duty of a teacher, that is to stand to the satisfaction of the stakeholders who in the universities and colleges are the students. Therefore, I'm not doing any charity, rather, I have tried to perform my duties and the responsibilities for which, as a teacher, I'm being paid by the university, by the government. Anyhow, and therefore, this type of performance, I think, is expected from all the teachers from primary school to the university or college level. Uh, Ladies and gentlemen, as I have already been introduced by the anchor of the program, Dr. Ahmed Mustafa Saab, that I have been teaching law subject in Faculty of Law, AMU Aligarh, and my area of specialization is family law. That has always been in discussion, debate, and controversy from bar to bench and at other public forums. Because there are various issues which have come up before the Supreme Court uh, in different form, uh, in the form of a writ petition matter has been raised before the Supreme Court. That subject basically I am teaching, and still there are various subjects of my area which are under contest before the Supreme Court, maybe polygamy, maybe halala system of halala system, which is just in some of the cases considered necessary as a intervening marriage. So there are so many issues, controversial issues, maintenance, etc., etc., custody of the children. So that is very controversial area that I have been dealing with for last several years as a teacher, and I try to discuss the current topics or the burning issues uh, that may be before the Supreme Court, pending before the Supreme Court, or may have been disposed by the Supreme Court, and maybe in the public domain. Anyhow, ladies and gentlemen, uh, as a teacher, here I am not here to deliver any lecture because I don't suppose myself that being a teacher I should give the lecture to the teachers. But of course, this is the forum for interaction, for discussion, for raising the issues. What are the issues which a teacher faces in individual capacity? What are the issues which are being faced by the community, teaching community, as a teachers as a community? What type of the challenges are before the educational system itself in current scenario, uh, in the given political system? So all these are the points which can be discussed later on. But of course, I have already given a topic that is expanding horizon of personal liberty with reference to Article 21 of the Constitution. Ladies and gentlemen, as all of you know that Constitution of India is a sacrosanct document drafted by the framer of the Constitution after hard labor for several years. This document was drafted, prepared, and was adopted on 26 November 1949. And later on, it was more than after 1 year, almost after 1 year, it was uh, enforced on 26 January 1950. And therefore, one date is the date of adoption of the Constitution, and other date is the date of enforcement of the Constitution. All of you may be well aware, being a teacher of school or college, discipline may be any, maybe science, maybe arts, maybe social science, etc., etc. But I think these are the basic or fundamental information that may be in the notice of each and everyone who is a teacher of any school or college. Basically, sometime there may be a question: what is the Constitution, or what is the constitutional law? Constitution basically is a set of the rules or system that defines the composition of various organs of the government which are necessary for the running of the country, as well as what is the relationship between the various organs of the organs which are created by the Constitution under the scheme of the document, that is the Constitution itself, as well as the Constitution also defines what is the relationship of this document or Constitution with the public at large. Because the Constitution is not only a document which defines the composition of the government, the composition of the various organs of the government, their power, their function, but at the same time, this document is also a document for the welfare of the people of the country. And therefore, it also defines, it also point out what is the nexus or relationship between the Constitution as well as the public at large, that is the stakeholder or the who are the beneficiaries, or what is the relationship of this document, this Constitution, with the public at large. Now, so far as the constitutional law is concerned, constitutional law is little bit different from the Constitution itself. Constitution defines the basic structure of the various organs of the government, composition of the various organs of the government, their mutual relationship, inter se relationship, as well as the relationship with the public at large. For example, there are three basic organs of the government. Everybody may be aware: legislature, executive, and judiciary. These are the three main pillars of the government. They are called as the constitutional organs of the government. In the entire structure of the government basically rests on these three pillars, or you can say that the country is run, a state is run through these three organs, and therefore it is necessary to define the interrelationship among these organs of the government. So, what is the composition of the legislature? What constitutes the legislature? Who can be the legislature? All these things are well defined by the constitution. What are the basic qualifications for a person to become the uh, member of the parliament, member of the state legislature? So, what is the legislature? According to the constitution, what consists of the legislature, it is well defined under the scheme of the constitution. At the same time, executive is another organ of the state. According to the constitution, it is also a separate independent organ of the government or state. What is the executive? What consists of the executive? What are the powers? What are the functions of the executive? What are the limitations imposed by the constitution on the power as well as functioning of the executive? That is also indicated, pointed out under the scheme of the constitution. Ladies and gentlemen, there is another organ uh, of the government created under the scheme of this national document that is known as constitution, and that is most important organ of the government, that is called as judiciary. I have said that it is a most important organ of the state or government as compared to the legislature, executive. There is sense, there is reason, not only reason but there are reasons, because uh, under the scheme of the constitution, judiciary, Indian judiciary, is the last hope of the last person of this country. Therefore, as compared to other organs, this unit of the government is considered, rather is accepted one and all as most important organ of the government. And it is also evident, it has also been proved by the time itself. Significance of the judiciary, role of the judicial system, is well established. Of course, there is a scope for criticism also, because judicial system is also run after all by the human agency. Therefore, in the words of Justice Krishna here, judiciary is also not infallible. Sometimes uh, some errors happens. Even these errors are also reflected in the judgments itself. Therefore, there is a procedure, there is a provision for the review and the revision or the appeal of the judgment or order given by the court itself. There is a hierarchy of the courts. But anyhow, this is one of the most important organ of the government, because this is considered as the last hope of the last person of this great country, that is India. So constitution, this is the gift of the Indian constitution, that we have a system of the governance, and therefore the constitution has not only created, has not only built up these various organs of the government for the smooth running of the country, for the welfare of the people, for the development of the country, for the advancement of the people of the country. But at the same time, what will be the interrelation of between one organ and other organ? And not only this, what are the powers and what are the function of the individual organ, that has also been uh, defined, has been uh, laid down by the framer of the constitution uh, under the various provisions of the constitution or articles of the constitution. And the most important thing which is uh, worth mentioning here, that our framers of the constitution not only created the organs like executive, judiciary or legislature, not only defined their composition, not only gave them powers and function, but at the same time also well defined the limitation of every organ of the government, that is of the state concern. If the legislature is given a power to legislate the law, what type of the law can be enacted by the government? What law should be enacted by the government? And therefore, now the constitution also points out that the law should not only be law, but it should be a just and fair and law for the welfare of the people. So limitation, power has been given, power is given to legislate the law to the legislature, but at the same time certain limitations has been imposed on the legislature. Relationship has been created between the center and the state, and therefore is center cannot usurp in the area of the state, and state cannot encroach or is not allowed to encroach upon the power of the center. Legislature is given the power, but at the same time legislature is not supposed to encroach upon the power of the executive, not to interfere in the functioning of the executive. These are the limitations operating on the working of the legislature. At the same time, both the legislature as well as the executive are not empowered to interfere or influence in any way the working or the justice delivery system, which is the exclusive domain of the judicial system created by the constitution. So power has been given, function has been defined. At the same time, jurisdictional limitation has also been explained by the constitution. Therefore, this document is uh, basically the fundamental rule. This document basically embodies the fundamental rules with limitations for the governance, for the good governance of the country by the people in power. Ladies and gentlemen, and my dear colleagues, rather, Constitution of India, being a document of national importance, embodies various rights, and some of the important rights for the people of this country, for the citizen of this country, are guaranteed under Part 3rd of the Constitution, that is known as fu- fundamental right. They are known as fundamental rights. Under the scheme of the Constitution, fundamental rights are guaranteed under Part 3rd, running from Article 12 to Article 35. So Article 12 to Article 35, Part 3rd of the Constitution, guarantees uh, fundamental rights for the people or citizens of this country. Uh, of course, undisputedly, all the rights which are known as fundamental rights, they are equally important. Being equally important, they are embodied under Part 3rd under different title or caption. There is another chapter under the scheme of the Constitution, that is uh, Part 4, that embodies directive principle of state policies from Article 36 to Article 51. Uh, fundamental directive principle of state policies are enshrined under the different name, under the different articles. There is another chapter that is that guarantees fundamental duties or incorporates the fundamental duties, and Article 51A basically guarantees the fundamental duties for the citizen of this great nation, that is India. Whereas the entire constitution is significant, there are so many other things. They are also provided, guaranteed under the various under various chapters of the constitution. Other rights are also guaranteed, but fundamental rights, directive principle of state policies, and fundamental duties are most significant part of this document that is known as Constitution of India. Ladies and gentlemen, so far as the fundamental rights are concerned, out of the bunch of fundamental rights, Article 21 of the Constitution is most important fundamental right guaranteed under Article 21 of the Constitution. This article, that is Article 21 of the Constitution, is most spoken, discussed, and interpreted article of the Constitution. If you have the chance to go through the judgments rendered by the Supreme Court of India, no judgment you will find without having the discussion and interpretation of the Article 21 of the Constitution. Because all the rights, directly or indirectly, are connected to the Article 21 of the Constitution. In other words, you can say that the existence, the survival, the development of the personality of the individual human being is based on the spirit of the Article 21 of the Constitution. Without Article 21 of the Constitution, the life of the individual will be meaningless. It will be just like the life of the animal or non-human entities. Because the survival of the human being basically is connected with the Article 21 of the Constitution. Therefore, this is considered most important article within the frame of the Constitution, particularly under the scheme of the fundamental rights. Just I am giving the example. Of course, there is Article 14 of the Constitution. There is Article 21 of Article 15 of the Constitution that speaks about the reservation. Article 14 of the Constitution speaks about the equality before law and equal protection of laws. Interpretation of Article 14 of the Constitution, or interpretation or meaning of equality before law or equal protection of laws, is based on the horizon of Article 21 of the Constitution. Article 15 of the Constitution, 16 of the Constitution, they speak about the reservation. But even the reservation, rule of the reservation, is also connected to the right to life and personal liberty of the Constitution. Because right to life has been read not only a bare existence of human being, but survival of the human being with human dignity in the given circumstance. Therefore, even the reservation, the provision for the reservation made under the scheme of the Constitution as a special package is meant to provide opportunity for already deprived class of the society to lead a dignified life henceforth, taking the advantage of this provision, that is of the reservation. So thus I was emphasizing over the, because normally we understand that right to life means protection against the arrest, detention without authority of law, or physical of that physical restraint, or deprivation of life and liberty without law. Simply, and this was the position before, or you can say that before the decision of the Supreme Court in Maneka Gandhi case. Before the Menka Gandhi case, Article 21 was in existence. Same wordings were codified under Article 21 of the Constitution. No one can be deprived of his life and personal liberty except according to procedure established by law. This is the one line Article 21 of the Constitution. But on this one line of Article 21 of the Constitution, the future of each and every individual of this country depends. Had there not been Article 21 of the Constitution, you cannot imagine what could have been the position of existence of the individual human as well as of the society. There could have been total anarchy in the life of the individual as well as in the collective life of the society. This is the importance of the Article 21 of the Constitution. So I was talking that before Menka Gandhi versus Union of India, everybody, I think, you may be aware who is Menka Gandhi. I think everybody will be aware. And what happened in Menka Gandhi case in brief? Menka Gandhi, basically, an inquiry proceeding was going on against the Menka Gandhi. And during the pendency of the inquiry, Menka Gandhi wanted to travel abroad for some personal reasons. When it came to the notice of the government instrumentality, that is passport authority, exercising the power conferred on it under Section 10 of the Passport Act, the passport of Menka Gandhi was impounded, was seized, and since the passport was impounded by the passport authority, therefore she was not allowed to leave the country, and she was forced to cancel her abroad trip. Then Menka Gandhi approached to the authorities as to why she has been deprived of, why her passport was impounded, not allowed to travel the abroad. The authorities did not disclose the reason for impounding the passport from Menka Gandhi, the petitioner, who was the petitioner in this case. Menka Gandhi was. She approached to the Supreme Court, filed a writ petition. Her writ petition was admitted, and matter was decided by the Supreme Court. Interpretation and counter interpretation of Article 21 was made before the bench of the Supreme Court. And in the course of argument, two decisions of the Supreme Court, A.K. Gopalan and Khadak Singh case, these two cases were frequently referred. And in Menka Gandhi case, these two cases were extensively discussed. Rather, you can say that the ratio decidendi, that is the decision, the crux of the decision of the Supreme Court in A.K. Gopalan and Khadak Singh case were reopened and discussed at length in Menka Gandhi case, because in A.K. Gopalan and in Khadak Singh case also expression personal liberty was debated at the forum of the Supreme Court. In A.K. Gopalan case, basically A.K. Gopalan was a communist leader, uh, and being a communist leader, he was arrested and detained for some reasons. I'm not taking background, that is a long story. But uh, he was detained and he filed a writ petition on the ground that right to life also includes right to movement. And he tried to connect in A.K. Gopalan case, the council of the A.K. Gopalan made all possible effort to expand the ambit and scope of Article 21 of the Constitution to the extent that it also includes the right to movement as guaranteed under Article 19 of 1 of the Constitution. And therefore, in A.K. Gopalan case, the argument was made on behalf of the petitioner that Article 21 will be meaningless without inclusion of right guaranteed under Article 19(1) of the Constitution. And therefore, the argument was that meaning of right life also meaning of the freedom of movement as guaranteed under Article 19, clause 1 of the Constitution. But the Supreme Court did not agree with the argument and said that right to life and personal liberty has a limited meaning, and its meaning extend only to the extent of a total deprivation of life and liberty without law. Means that if somebody has been arrested or somebody has been detained by the state agency without proper law, without any law, only then Article 21 will come to his or her rescue. But right to movement and freedom of speech and expression, they are the different type of the rights available under the different situation, and therefore this right will not extend to include the right guaranteed under Article, and therefore are taking the advantage of subclass 5 of Article 19, the very restricted interpretation of the word life and liberty was given in A.K. Gopalan case. Then other case was Khadak Singh case. In Khadak Singh case, Khadak Singh basically was uh, accused of offense of Dakaiti, and he was released. But in the release order, the condition was that he will stay at his place, designated place, and he will not go, particularly in the night, he will not go out of place of the residence indicated in the release order. And therefore, police, in the exercise the its power, kept continuous surveillance on the movement of Khadak Singh. And therefore, the police frequently used to visit his place of residence uh, in late night, used to knock his door, check him, is he available in the house or not, just in order to ensure that he is within his designated place or not. So then Khadak Singh filed a writ petition, taking the advantage of Article 21 of the Constitution, that this is encroachment upon his right to privacy, because in the night he is entitled to uh, have a full sleep night, and continuous disturbance or surveillance over his stay basically amounted the violation of his privacy, which is implicit in the uh, liberty, expression liberty, as guaranteed under Article 21 of the Constitution. The Supreme Court tried to extend the concept of the liberty by giving the interpretation, and Supreme Court in Khadak Singh case to some extent agreed that right to life includes a dignified life, a dignified survival, and therefore continuous surveillance or checking, especially in the night, amounts the encroachment upon the privacy of a person. And privacy is, if not explicit, it is implicit in Article 21 of the Constitution, and therefore this type of the action on the part of the state is violation of Article 21 of the Constitution, and therefore this is not allowed, because the police uh, department pleaded that they are permitted under the police manual to take such type of the action. Anyhow, this is the long story. Matter these two decisions were discussed in Maneka Gandhi case, because Maneka Gandhi also challenged the impounding of passport by the passport authorities as violative of a right to life and personal liberty guaranteed under Article 21 of the Constitution. And petitioner pleaded that Article 921 should be read along with Article 19 of the Constitution, that allows the freedom of movement, freedom to travel from one country to another country, and also challenge on the ground that passport was impounded by the passport authority without disclosing any reason, and non-disclosure of the reason is also violation of the rule of natural justice, because natural justice principle, corner principle, or the fundamental principle of natural justice is that one cannot be condemned unheard. Means one cannot be deprived of his or her any right without being afforded the opportunity of being heard. And therefore, if a passport is impounded without affording the opportunity, without disclosing the reasons as to why her passport was on what ground, for what reasons, the authorities, the government authorities, they gave the reasons that passport law does not require the passport authority to disclose the reason, and therefore Since law does not require the passport authority to disclose the reason, therefore the reasons were not uh, given. Second thing, that it is not necessary that in all the matters the reason, because law does not allow, in law it is not provided, and therefore the government is not, or authority is not bound to disclose the reasons. Then Article 21 of the Constitution was interpreted by the court, whether disclosure of is violative of Article 21 of the Constitution or not. And uh, what is the meaning of law enacted by the government? These 2 points were basically discussed. In nutshell, the court came to the conclusion that law not only means the law enacted by the parliament, but law means law enacted by the parliament which is just, fair, and reasonable. So the court uh, laid down the test for a valid law. There should not only be the law enacted by the parliament, but law must be a valid law. A valid law means any law to be regarded as valid must qualify certain test, and the test was laid down by the Supreme Court while interpreting Article 21 of the Constitution in Maneka Gandhi case, that law must be just, law must be fair, and law must be reasonable. If any law enacted or made by the parliament or state legislature is just, fair, and reasonable, then such law will be regarded as valid law within the meaning of Article 21 of the Constitution. And therefore, if there is any law which fails to pass these tests, then such law will not be valid and will be considered as ultra virus and will be liable to be struck down by the courts, apex court or the high courts, in the exercise of power of the judicial review. Therefore, friends, you might have seen that various laws which have been enacted by the government have been struck down by the Supreme Court of India uh, in the exercise of the power of judicial review. That is the very important power which is available to the Supreme Court as well as the High Courts of. So one thing, that law should not only be the just, fair, and reasonable, but it should be the law should be just, fair, and reasonable. It should not be a law merely enacted by the parliament. And also at the same time, the facet of Article 21 of the Constitution was also interpreted by the Supreme Court. And the court pointed out in its judgment that life doesn't mean a bare life. Life doesn't mean animal life. But the court said that life as envisaged under Article 21 of the Constitution means a dignified life. And therefore, where there is life but there is no dignified life, then this will not be regarded as a life within the meaning of art. Therefore, uh, everything which is necessary for the dignified survival of a human being, all such things are liable to be read within the meaning of Article 21 of the Constitution. And life doesn't mean the bear are mere animal, and therefore a right to education, because we all belong to the this field, that is field of the education. Earlier, this right to education was not a fundamental right, but now it is the integral part of the fundamental right. It is uh, it was added as Article 21A, and under Article 21A, now the this right to education is as a fundamental right, and therefore any person who is deprived of this right by the state or by any government agency is entitled to uh, claim it by invoking Article 21 of the Constitution if other conditions are being fulfilled. So, because why the right to education has been read within the meaning of, because now right to education has been read in the meaning of right to life, because Article 21 of the Constitution guarantees right to life, and the right, when right to expression life is interpreted according to the successive judgment delivered by the Supreme Court, right to life means a dignified survival in a given circumstance. And therefore, whatever is essential, whatever is indispensable for dignified survival of a human being, every such thing will be considered as part of Article 21 of the Constitution as a necessary part of the life. In the course, in the beginning, the right to education was not as a fundamental right, but in Indira Sahni case, yeah, Indira Sahni versus Union of India case, the Supreme Court itself uh, uh, interpreted the Article 21 of the Constitution further beyond the existence, and said that for the dignified existence in the society, uh, the minimum education is necessary. And therefore the government is under the obligation, under the constitutional obligation, to make the necessary arrangement up to certain level, at least for up to certain level, for the education of the people of this country. And therefore right to education act was enacted, and now education up to certain level has been made free and compulsory. Why the right to education has been regarded as part of the fundamental right? Reason, because in Menka Gandhi case was stated by the Supreme Court that right to life means a dignified survival, a right to live with the dignity, not bare existence, but existence with honor, existence with existence of the individual with the dignity, with honor. And for dignity and honor, it is necessary that the government should make the necessary arrangement for the basic education of the citizen of this country. This is the part of the life. Without education, life is meaningless. In view of the judgment of the Supreme Court in Maneka Gandhi as well as Indira Sahni case. And therefore now the right to education is and in this way the horizon of Article 21 was expanded from bare existence to the dignified existence. Right to privacy. In Khalak Singh case, privacy was not accepted. Of course, it was acknowledged that privacy is necessary. It should be maintained, but it was not uh, uh, explicitly accepted as part of Article 21 of the. But in Puttu Swami case, this Puttu Swami, he was the judge of the Madras High Court. Recently, he passed away. He filed a writ petition uh, uh, when the government was collecting the data for Aadhaar, etc., etc. So, इसको लगाओ वरना तो इसका वो जा रहा. Just 1 minute break I will take. Just this is getting down. Network is getting down. लगाओ. लगा दिया. लगा दिया. लगा दिया. चलो ठीक. आवाज आएगी ना. ठीक ठीक. So, dear colleagues, I was talking about the expanding dimension of Article 21 of the Constitution. And day by day, the Supreme Court is extending the nature and scope of Article 21 of the Constitution. Now, even in the light of expanding horizon of Article 21, now many questions, now the same-sex marriage, decriminalization of this adultery, right to produce or refuse to produce the child or children, right to shelter, all these now are being read within the meaning of right to life and liberty guaranteed under Article 21 of the Constitution. There are so many rights related to the women. Now they are being claimed under Article 21 of the Constitution. Now, having the relationship or copulation with the wife below the age of 18 years is now an offense. because uh, one who is below the age of 18 years, she is not supposed to be capable of giving the consent. So now the consent of the individual uh, is read as a part of the right to the life, and therefore now, since we all are the part of the society, we know that a marriage between the two persons uh, without mutual valid consent is null and void. Whereas on the face of the record, union of the marriage has no connection with the uh, Article 21 of the Constitution. But when there is interpretation is made of Article 21 of the Constitution, uh, it extends to uh, encompass even consent of the individual within the meaning of Article 21 of the Constitution, because in the union of the marriage, basically, all of you know that marriage is basically the union of two persons of the opposite gender. Now it is maybe of the same sex also. But in our traditional or customary societies, uh, up to the decision of the Supreme Court permitting the same-sex marriages, now it is uh, still under contest whether a same-sex couple will have the status of the marriage, whether the same-sex marriage will confer the status, certain status or not. Will they be called as married people, people having the status of the marriage? Whether this union will be worth calling the marriage or not, this is still under contest. But uh, again, pleading is going on that this is a choice of the people. A choice of the people, two persons, is can be read within the Article 21 of the Constitution anyhow. But in traditional cases, marriage basically is the agreement of mind between the two persons. And for agreement, there must be consent of the parties. And for consent, parties must be adult, must have attained a certain age prescribed by law. And therefore, now, if marriage has taken place between the two persons and one is below the age of 18 years, and when she is below the age of 18 and she has been subjected to the relationship, then it will amount the unoffice, because at that point of the time she was not capable of giving the valid consent, was not of marriageable age. And therefore, even Article 21 has gone to this extent that a marriage without valid consent is void marriage. Now it is being declared as void. Earlier it was voidable simply, but now it is going to be declared as, because the uh, age is must, and for age there must be, one must be capable. So meaning thereby that horizon of Article 21 is being extended day by day, and uh, it has included within its meaning so many rights: right to shelter. And therefore now the government of India is launching the shelter scheme, Pradhan Mantri Grih Yojana, etc., etc. Right to food. Now this is also the part of the art life of Article 21 of the Constitution. एंड देयरफॉर जो आप लोग देख रहे हैं कि गवर्नमेंट जो ये पैकेजेस दे रही है, जो गांवों में, देहातों में आप देख रहे हैं कि बिलो पॉवर्टी लाइन के लोगों को गवर्नमेंट जो है वो फ्री अनाज दे रही है, जिसको हम लोग कहते हैं कि फ्री बाइस है, फ्रेवड़ी है। बेसिकली ऐसा नहीं, अगर आप ये देखें तो ये पार्ट ऑफ आर्टिकल 21 ऑफ द कॉन्स्टिट्यूशन, and pursuant to the obligation imposed by Article 21 of the Constitution, government has launched certain scheme. और ये फूड सिक्योरिटी एक्ट भी पास हो गया है। फूड सिक्योरिटी एक्ट जो पास हुआ वो बेसिकली इसी लॉ के यानी आर्टिकल 21 के मैंडेट के तहत पास हुआ है। राइट टू इंफॉर्मेशन, राइट टू आरटीआई एक्ट सभी लोग जानते हैं। आरटीआई एक्ट बेसिकली आर्टिकल 21 का ही ऑफशूट है। Basically, this law has been passed pursuant to the mandate of Article 21 of the Constitution, because right to know is a fundamental right. In Menka Gandhi case, this was the pleading that right to know is the fundamental right. Government was saying that right to know is not a fundamental right because the Article 21 has its own limitation. But now the Supreme Court in Menka Gandhi case said that right to, ultimately held that right to know is the part of Article 21 of the Constitution. It is the part of the fundamental right. And ultimately government was forced to enact the law of, that is the right to information. So right to information basically is the part of the fundamental right. Everybody has right to know what is happening or what is happening at the grassroots in the government corridor. कौन सी policy, if somebody has been taken into custody now by the police, now the police has to disclose the reasons as to why he is being taken into custody, and therefore he has the right to be produced before the magistrate within the 24 hours, so that the reasons may be disclosed before the magistrate. Magistrate may examine whether the arrest of the person is valid or illegal. Right to be examined by the medical practitioner. अगर किसी आदमी को अरेस्ट कर लिया गया है तो सबसे पहले जो है ये पुलिस को ये बताना होगा, भले ही हो तो प्रैक्टिस में क्या हो रहा है वो एक अलग चीज है, लेकिन कानून यही है कि as soon as any person is being arrested and taken into custody by the law enforcement agency, he must be informed the ground of his arrest. D.K. Basu versus State of West Bengal. Detailed guidelines have been laid down by the Supreme Court regarding the arrest and detention. And if any arrest is in violation of the grounds laid down in D.K. Basu versus State of West Bengal, such arrest will be declared illegal, violative of Article 21 of the Constitution. It may be considered as a wrongful restraint, and therefore arrested person may be compensated. तो आर्टिकल 21 आपका होराइजन बहुत बढ़ता चल, आप देखा होगा कि साहबानों का केस आया, आप सभी लोग साहबानों के केस जजमेंट से आप वाकिफ होंगे। साहबानों के जजमेंट में बेसिकली जो है वो एक आ गया, क्योंकि इसमें कंट्रोवर्सी थी मुस्लिम लॉ में और आर्टिकल सेक्शन 125। यहाँ बहुत ज्यादा डिटेल में नहीं जा रहे हैं क्योंकि हो सकता है आपको समझ नहीं, लेकिन सुप्रीम कोर्ट ने साहबानों के केस में ये कहा कि अगर कोई औरत या कोई वीमेन है जिसको उसके हस्बैंड ने डाइवोर्स दे दिया है and she is unable to maintain herself out of her own economic resources, then she cannot be left to lead a destitute and vagrant life at the mercy of the society. और यहाँ यही बात आई कि अगर उसके पास इतना रिसोर्सेज नहीं कि वो एक अपनी डिग्निफाइड लाइफ अपना लीड कर सके, तो कोर्ट ने कहा कि ये दिस इज द मैंडेट ऑफ आर्टिकल 21 कि एक आदमी जिसका डाइवोर्स हो गया है अगर उसके पास कुछ नहीं है अपनी जिंदगी को गुजारा, तो ये दिस इज द रिस्पॉन्सिबिलिटी ऑफ द फार्मर हस्बैंड टू मेंटेन हिज वाइफ until she remarriages or becomes independent, economically independent. तो ये जो साहबानों का पूरा जो जजमेंट था वो भी बेसिकली इर्द गिर्द आर्टिकल 21 के ही था। उसमें मुस्लिम पर्सनल लॉ को आर्टिकल 21 के लाइट में पढ़ा गया, 125 को 120 आर्टिकल 21 से, क्योंकि हर चीज का जो है मैंने कहा ना कि डिग्निफाइड सर्वाइवल, कोई भी आदमी अगर किसी को उसका जो राइट है अगर उससे डिप्राइव किया जाता आर्बिट्रेरी अगर कोई आगे किसी आदमी को अगर कोई पुलिस वाला अरेस्ट करता है विदाउट डिस्क्लोजिंग द रीजंस, इसका मतलब ये आर्बिट्रेरी एक्शन है। और आर्बिट्रेरी एक्शन जो है वो बेसिकली दैट हिट्स टू आर्टिकल 21 ऑफ द कॉन्स्टिट्यूशन। इसी तरीके से किसी कोई जैसे कोई लेडी है उससे जबरदस्ती जैसे शादी की वजह फोर्स मैरिज क्यों इलीगल मैरिज है? क्योंकि ये बेसिकली दिस इज द वायलेशन ऑफ आर्टिकल, दिस इज अगेंस्ट द डिग्निटी। चॉइस बेसिकली इज इनबिल्ट इन द राइट टू डिग्निटी। तो ये तमाम सारी चीजें हैं जो आर्टिकल 21 के दायरे में आती हैं, इसलिए आर्टिकल 21 का जो है बहुत ज्यादा एक्सपेंशन हो गया है। और अब तो तमाम वो सारी चीजें हैं जो आर्टिकल 21 के तहत आ गई, जो अब तक के नहीं है वो भी आ रही हैं सारी चीजें। जैसे हम लोग एजुकेशन की बात कर रहे हैं, एजुकेशन, अब देखिए एजुकेशन का मतलब ये नहीं है कि सिर्फ एजुकेशन नाम की डिग्री, एजुकेशन मीन्स ए क्वालिटी एजुकेशन होना चाहिए। अगर क्वालिटी एजुकेशन नहीं है तो इस राइट टू एजुकेशन का जो है समझने की वायलेशन हो रहा है। यानी अगर कोई यूनिवर्सिटी है वो सिर्फ डिग्री दे रही है, उसके यहाँ पढ़ाई नहीं हो रही, लेबोरेटरी नहीं है, क्लासेस नहीं हो रही हैं, लाइब्रेरी नहीं है। देखिए इसीलिए जब किसी स्कूल और कॉलेज का जो है रिकॉग्निशन का मामला होता है तो देयर आर सर्टेन पैरामीटर्स, कि इन पैरामीटर्स को जब पूरा करेंगे तभी जो है, क्योंकि क्वालिटी एजुकेशन के लिए एक तो क्वालिटी बिल्डिंग होनी चाहिए, क्लासरूम होनी चाहिए, लेबोरेटरी होनी चाहिए, वॉशरूम होनी चाहिए, तमाम ब्लैक बोर्ड होना चाहिए, सारी चीजें होनी चाहिए, यहाँ तक कि अप्रोच रोड भी होना चाहिए स्कूल और कॉलेज के लिए। ये सब राइट टू एजुकेशन का पार्ट है। बगैर इसके एजुकेशन कंप्लीट ही नहीं हो सकता। अगर एजुकेशन नहीं है तो आर्टिकल 21 का वायलेशन है। तो इस तरीके से एजुकेशन का यानी आर्टिकल 21 का जो है होराइजन जो है बहुत काफी किया है सुप्रीम कोर्ट ने, और बहुत सी चीजें ऐसी हैं जो इसके दायरे के अंदर ला करके, और इसके दायरे के अंदर इसलिए लाया गया है ताकि इंडिविजुअल सिटीजन ऑफ द कंट्री में लीड ए डिग्निफाइड लाइफ इन द गिवन सोसाइटी। दिस इज द क्रक्स ऑफ आर्टिकल 21। और इसीलिए वो सारी चीजें, तमाम चीजें जो नेसेसरी हैं एक डिग्निफाइड सर्वाइवल के लिए, डिग्निफाइड एग्जिस्टेंस के लिए इन द सराउंडिंग सोसाइटी में, वो सारी चीजें आर्टिकल 21 के तहत लाई जा रही हैं और लाया जा चुका है और लाई जा। और वो खासतौर से वीमेन, चिल्ड्रन, ओल्ड एज पेरेंट्स, इनके सब के बारे में देखिए अब कानून बन रहा है। और इसीलिए बन रहा है ताकि इवन लास्ट स्टेज में भी आदमी जो है अपनी जिंदगी लाइफ, एक डिफॉर्मेशन होता है आदमी को। देखिए आपने देखा होगा कि अगर आपने एक आदमी दूसरे आदमी को गाली दे दे तो उसके उस खिलाफ कार्रवाई होती है, केस दर्ज होता है, ट्रायल होता है, सजा होती है। गाली से ऐसा नहीं कि कुछ उसका नुकसान हो गया, लेकिन गाली से क्या होता है कि एक रेपुटेशन इन द पब्लिक डोमेन में खराब होती है आदमी की, यानी उसकी डिग्निटी के ऊपर असर होता है। और वो डिग्निटी जो है आर्टिकल लाइफ का पार्ट है। इसलिए कोई आदमी अगर किसी आदमी को बेवजह विदाउट एनी रीजंस अगर कुछ कह दिया है, उसकी डिग्निटी, उसके रेपुटेशन पे फर्क पड़ा है, तो उसके देखिए अब ऐसा सोशल मीडिया के ऊपर अगर किसी आदमी ने अनफाउंडेड कमेंट कर दिया है जिससे उसके रेपुटेशन पे फर्क पड़ रहा है, तो वो दैट इज द वायलेशन ऑफ आर्टिकल 21 ऑफ द लॉ, ही इज लायबल टू बी कंपनसेटेड। तो ये कुछ चंद बातें थी जो हमने आप लोगों के सामने आर्टिकल 21 के बारे में रखा। और बहरहाल इस पे तो अगर डिस्कशन किया जाए तो बहुत लंबा हो सकता है। अब अ, इसके अलावा भी, इससे हट करके या इससे कनेक्टेड भी अगर कोई सवाल आप लोगों के जहन में हो, आप कोई सवाल करना चाहते हैं तो हो जाए, ताकि एक इंटरेक्शन भी हो जाए, कुछ चीजें और हो जाएं जो आप लोग समझते हो। तो अगर आपके जहन में कोई सवाल हो, कोई चाहे इससे कनेक्टेड हो या कोई भी इसके अलावा भी हट के भी हो, तो आप, तो यू आर फ्री, यू आर वेलकम इन द फॉर्म ऑफ क्वेश्चन।
जी इस्लाम सर।
वालेकुम अस्सलाम।
सर मेरा नाम अब्दुल्ला है। और
अब्दुल्ला।
सर मैं आपसे, जी जी सर, और मैं
कहाँ से
आपसे एक
कहाँ से अब्दुल्ला?
जी सर मैं अलबरकात में हूँ।
अच्छा, यहीं पर अलीगढ़ में।
जी जी सर।
अच्छा अब्दुल्ला जी।
जी सर, मुझे पॉलिटिकल साइंस की बहुत अच्छी से नॉलेज या समझ तो नहीं है, लेकिन मैं कुछ चीज पूछना चाहता था आपसे।
हाँ हाँ रे, माशाल्लाह, बहुत बढ़िया।
सर मैं ये पूछना चाहता था कि जैसे अभी आपने आर्टिकल 21 में बहुत सारी चीजों का बहुत डिटेल में जिक्र किया, और उसमें आपने एक राइट बताया था, राइट टू रिप्रोड्यूस। तो सर जैसे मैंने ये पढ़ा है और अभी मैं देख भी रहा था कि जैसे राजस्थान ने गवर्नमेंट जॉब्स में उन लोगों को नौकरी नहीं देगी जिनके 2 से ज्यादा बच्चे हैं। तो क्या ये आर्टिकल 21 का वायलेशन नहीं है?
देखिए, ऐसा है, कोई भी जो राइट है, फंडामेंटल जो राइट है, वो कोई भी राइट अब्सोल्यूट नहीं है, अनकंडीशनल नहीं है। एवरी राइट इज सब्जेक्ट टू restrictions, but again, whatever restriction is imposed or limitations are imposed on the rights guaranteed under Article 21 or under any right guaranteed under Part 3 of the Constitution, that must be just, fair and reasonable. ठीक।
जी सर।
अब रह गया ये कि जहां तक कि आपने सवाल किया कि गवर्नमेंट ने इस पे एक रेस्ट्रिक्शन लगा कि जिसके 2 से ज्यादा बच्चे होंगे उसको हम गवर्नमेंट जॉब में अलाउ नहीं करें। ठीक। तो ये गवर्नमेंट की अपनी एक पॉलिसी है। ठीक है। और
जी सर।
गवर्नमेंट ने इसके जो है वो उसके अपने रीजंस, उसके स्टेटमेंट ऑफ ऑब्जेक्ट भी जो कानून बनाया होगा उसमें स्टेटमेंट ऑफ ऑब्जेक्ट भी दिया। तो उसकी वजह यह है कि ये जो रेस्ट्रिक्शंस हैं वो हमारी, चूंकि जो जो एक एक्सप्लोजन ऑफ पॉपुलेशन है, एक हो कह रहा है कि एक्सप्लोजन ऑफ पॉपुलेशन का डायरेक्ट असर हमारे एग्जिस्टिंग रिसोर्सेज पे पड़ता है, जो हमारे मटेरियल रिसोर्सेज हैं। तो
जी सर।
उस मटेरियल रिसोर्सेज पे पड़ने की वजह से क्वालिटी ऑफ द जो है लाइफ पे फर्क पड़ता है। और in order to ensure the quality of the life, now the government considers that it is necessary to control the population. जैसे मिसाल के तौर पे आपके पास 100 रुपया है, एंड 100 रुपये को डिस्ट्रीब्यूट अगर आप जो है वो 2 आदमियों में करेंगे तो 50-50 रुपये आ जाएगा। और उस 50 रुपये से कम कुछ जरूरतें एक आदमी अपनी पूरी कर लेगा। लेकिन उसी रुपये को अगर 100 रुपये को 100 आदमियों में आपको डिस्ट्रीब्यूट करना पड़े तो एक एक रुपया आएगा, वो एक रुपया किसी के काम का नहीं होगा। द रिसोर्सेज आर ऑफ द गवर्नमेंट, रिसोर्सेज आर बीइंग डिस्ट्रीब्यूटेड इक्वली among the equals, but resources on distribution becomes useless for all the 100 peoples. And therefore now, in order to make the resources useful, it is necessary that stakeholders should be restricted. And how the stakeholder can be restricted? For that, it is necessary that the production should be restricted. अगर प्रोडक्शन नहीं रिस्ट्रिक्ट किया जा सकता है, रिसोर्सेज तो हमारे वही हैं, तो इसलिए गवर्नमेंट अपना रीजंस देती है कि हम इस वजह से ये रूल लागू कर रहे हैं कि एक तरह से वो कर रहे हैं। तो बेसिकली दिस रूल हैज बीन इनेक्टेड परहैप्स in order to restrict the exploding number of the population which is going disproportionate to the existing resources. So in order to maintain a balance between the resources and populations, some check and balance uh, are put by the government, and government is giving this type of the reason of for putting this type of the restriction, which also has been upheld by the courts
Zishan,
in some of the cases.
Thank you.
Zishan.
Good evening, sir.
Good evening.
I am Dr. Indu Singh from IIMT College, Aligarh.
Okay.
सर मैं ये जानना चाहती थी कि राइट टू प्राइवेसी हमें मिला हुआ है आर्टिकल 21 में, तो लेकिन हर तीसरे दिन अगर आप देखें तो प्राइवेसी किसी की भी चोरी चीजें हो जाती हैं, फोटोग्राफ्स हैं, इनका यूज कर लिया जाता है और मेनी टाइम्स लोगों को पता भी नहीं होता। तो इस चीज को रोकने के लिए किस तरीके के स्टेप्स लिए जा सकते हैं?
नहीं, इसके लिए देखिए साइबर एक्ट बन गया है
जी।
और साइबर, अब मुझे इस वक्त पर वो, क्योंकि आप जानते हैं कि कानून बहुत ही वास्ट है, ये ओशन है हर चीज को, लेकिन बाकायदा ये फुल फ्लेज साइबर सिक्योरिटी एक्ट बन गया है और इसके तहत अगर कोई भी किसी की प्राइवेसी को डिस्टर्ब कर रहा है, अभी मैंने खुद ही एज ए प्रॉक्टर हमारे यहाँ के कुछ बच्चों का, जैसे वो बच्चे बैठे हुए हैं, उन्होंने जैसे उनका फोटोग्राफ ले लिया विदाउट देयर कंसेंट। यू सी दैट अगर विदाउट देयर कंसेंट समबडी हैज टेकन द फोटोग्राफ को और उसके नीचे उन्होंने कुछ ऑब्जेक्शनेबल कमेंट भी लिख दिए, तो वो जो है उसके लिए देखिए इंफॉर्मेशन टेक्नोलॉजी एक्ट 2005 शायद है, 2005 है, 2000 इंफॉर्मेशन टेक्नोलॉजी एक्ट 2005, उसके तहत भी प्रोविजन है कि अगर इस तरीके से का कोई काम करता है तो उसके खिलाफ FIR हो जाएगी और आफ्टर इन्वेस्टिगेशन ही कैन बी प्रोसिक्यूटेड फॉर सर्टेन पीरियड ऑफ टाइम।
Now time is going to be over. Please.
नहीं सर, पूछ लेने दीजिए एक आध सवाल, अगर और कोई पूछना चाहे तो पूछ ले। तो साइबर सिक्योरिटी एक्ट भी आ गया, इंफॉर्मेशन टेक्नोलॉजी एक्ट भी आ गया है और इस तरीके से अगर किसी की प्राइवेसी को इन्फोर्समेंट होता है तो उसके खिलाफ एक्शन की प्रोविजन है। हाँ,
हेलो सर, आई एम डॉक्टर आगा फ्रॉम अलबरकार। सर, बहुत सारे राइट्स तो हमें मिले हैं लेकिन उसका इम्प्लीमेंट के हिसाब से लगता है कि बहुत नहीं हो पा रहा है, तो उस सूरत में आपका क्या ख्याल है?
एग्जेम्पशन लिया 3 बज के 45 मिनट।
देखिए ऐसा है कि आप बिल्कुल आप सही कह रहे हैं, इसको कभी कभी गवर्नमेंट भी एक्नॉलेज कर रही है और इसीलिए बहुत सी कमिटीज कमीशंस बनाए जा रहे हैं कि हाउ टू एक्सटेंड द बेनिफिट टू द पब्लिक। जैसे गवर्नमेंट ने पहले स्कीम बनाया था, मनरेगा का बनाया था, और इसके अलावा जैसे जो किसानों को कुछ बेनिफिट दिया जा रहा था तो वो नहीं पहुंच पा रहा था। जब गवर्नमेंट के पास, जैसे आपने एक बात कही है, इंफॉर्मेशन की, तमाम किसानों के जो है अकाउंट खुलवाए गए और डायरेक्ट ट्रांसफर, तो जब कोई कानून बनता है, कोई चलता है तो उसको रेक्टिफाई जो है गवर्नमेंट स्टेप लेती है। आप बता रहा हूँ, पहले भी किसानों को जो है जैसे कोई स्कीम अनाउंस की जाती थी, जैसे एक मैं बता दूं आपको, जो लोग 60 साल कुछ एज थी और 1,000 रुपया पर मंथ या कुछ ऐसे देने की बात। अब उसमें क्या हुआ कि गवर्नमेंट आता था लेकिन पिछवलिया उसमें आधा से ज्यादा पैसा खा जाता, इसमें बाकायदा डेटा सबमिट किया गया। इसके बाद में डायरेक्ट अकाउंट को, अब देखिए सब डिजिटल पेमेंट हो रहा है, तो उस डिजिटल पेमेंट की वजह से अब डायरेक्ट बेनिफिट, जैसे किसानों को जो है 6,000 रुपया पर एनम गवर्नमेंट ने अनाउंस किया है। अब जिनके अकाउंट खुल गए सीधे उनके अकाउंट में तो 6,000 के 6,000 आ रहे हैं। तो ऐसा नहीं है कि नहीं हो पा रहा है, बहुत सी चीजें हैं। अब अगर कोई इसको पॉइंट आउट करता है तो चीजें डिस्कस होती हैं, उसका इम्प्लीमेंटेशन होता है, इसी बात है। अब जैसे मिसाल के तौर पे आपको बता दें कि साहब ये रूल ये है कि क्लास टीचर को क्लास में जाना चाहिए, अपना पढ़ाना चाहिए। अब बहुत से टीचर हैं नहीं जाते हैं। अब मसला ये कि अगर इसकी रिपोर्ट पूरे प्रिंसिपल तक पहुंचती है तो प्रिंसिपल उसको करता है, प्रिंसिपल उसका ध्यान देता है, उसको नोटिस देता है, उसको शोकाज देता है। अगर कोई ज्यादा हो तो उसके खिलाफ इंक्वायरी हो जाती है, उसके सर्विसेज टर्मिनेट होती हैं और उससे दूसरे लोगों के ऊपर असर पड़ता है, दूसरे लोग जाने लगते हैं। तो ऐसा नहीं है, देखिए ऐसा है कि जहाँ कानून है उसका वायलेशन होता है, इसीलिए उस वायलेशन को रोकने के लिए कुछ प्रिवेंटिव मेजर्स भी दिए जाते हैं, उसकी लॉ के अंदर इनबिल्ट होते हैं। तो जो बात आप कह रहे हैं वो अपनी जगह पर हो सकता सही हो, लेकिन ऐसा नहीं, गवर्नमेंट साथ साथ में स्टेप लेती है कि वो चीज वहां तक पहुंचे। और अगर मान लिया उसमें कोई लूप होल नजर आता है तो उसको मैंने कहा नहीं, इम्प्रूव करने के लिए कमिटीज बनती हैं, कमीशन बनते हैं, रिकमेंडेशन आता है और फिर उसको इम्प्रूव किया जाता है। अब आप देख लीजिए, अभी आज ही बात हो रही थी हमारी यूनिवर्सिटी के अंदर कि सब अटेंडेंस को कैसे इंश्योर किया जाए। तो एक बात आई कि सब डिजिटल अटेंडेंस कर दिया जाए कि लड़का क्लासरूम में जाए और टीचर जाए तो वही फौरन पहले अंगूठा लगाए तब जाए, तो इससे पक्का हो जाएगा कि क्लास में आया। कि अदरवाइज जैसे ये बात आ रही थी कि सब कुछ लड़के आते तो उनकी भी लग जाती, जो नहीं आते वो भी लगवा लेते हैं अटेंडेंस। तो जब डिजिटल एक बात आ रही है, एक सिस्टम में लूप होल नजर आ रहा है, तो उसको रिमूव करने के लिए आज ये बात हुई है कि साहब डिजिटल अटेंडेंस का प्रोविजन किया जाए ताकि ये 100% एक्यूरेसी के साथ आ जाए कि हाँ लड़का क्लास में आया कि नहीं आया, टीचर क्लास में आया कि नहीं।
थैंक यू सर।
अस्सलाम वालेकुम सर।
वालेकुम
Now
अस्सलाम।
time is going to be over.
सर
हेलो
जी सर, जी सर, जी डॉक्टर साहब।
बहुत अच्छे इंटरेक्टिव सेशन रहा। मेरी आवाज में माइक भी खुल गया था। तो आज हमारे अलबरकात के टीचर्स ने भी आपसे काफी इंटरेक्ट किया और तमाम टीचर्स ने भी किया। और व्हाट इज योर ओपिनियन, हमारे पार्टिसिपेंट्स, कैसा लगा आपको? देखिए
आपने
बहुत
सारे
अच्छे
सारे 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 पार्टिसिपेंट्स को तो आपने छुपा के रखा है। तो बहरहाल सभी मुझे लगता है कि जिन लोगों ने बात किया है कि बहुत अच्छे लग रहे, बहुत अच्छे अच्छे सवाल किए हैं, प्रैक्टिकल सवाल किए।
नहीं मैंने आपसे शुरू में ही कहा था कि मैंने आपसे शुरू में ही अर्ज किया था कि, और देखिए कितना थैंक्स आ रहे हैं, कितने आपके जो है वो अप्रिशिएट कर रहे हैं।
नहीं नहीं, मैं
बहुत
भी
ही इंटरेक्टिव है।
जी सर, डॉक्टर
सो
साहब मैं सबसे बढ़ने कहा था, मैं वन लाइन में आपको आपके पार्टिसिपेंट की मेरिट को बता रहा हूँ कि जितने सवाल किए हैं बहुत ही प्रैक्टिकल सवाल किए हैं, यानी जो डायरेक्ट सोसाइटी से रिलेटेड सवाल हैं, जो डे टू डे लाइफ में लोग फेस कर रहे हैं, उन सवालों को किया है और उनका क्या पॉसिबल सोल्यूशन हो सकता है उस उम्मीद से किया है। तो मैं समझता हूँ कि बहुत ही अच्छे, आपके बहुत ही जागरूक जो है वो पार्टिसिपेंट हैं। और सिर्फ यही नहीं, वो जो चीजें किताब में हैं उसको जानते हैं। लेकिन अच्छी बात यह है कि दे आर बीइंग द पार्ट ऑफ द सोसाइटी, दे आर हैविंग द एक्सपीरियंस ऑफ द सोसाइटी एंड दे आर पॉइंटिंग आउट बेसिकली द पेन एंड प्लेजर ऑफ द members of the society as a representative. Basically they are representing to the pain and pleasure of the society as a whole. तो ये एक अच्छी बात है। सबसे अच्छी बात जो मैंने नोट किया वो ये है कि सिर्फ ये नहीं कि किताबों की चीजें पूछ लिया, बल्कि जो हैपनिंग एट द ग्रास रूट लेवल उस चीज को उन्होंने सामने रखा है। तो एक अच्छी बात है, बड़ी अच्छी बात है। यही एक डायनामिक टीचर की यही एक पहचान है। Having a cross finger over the society, problems of the society, basically यही डायनामिक टीचर की पहचान है, मैं समझता हूँ।
बहुत बहुत शुक्रिया। At the very outset of this session, I am extending my heartfelt gratitude and thanks to respected Professor Wasim Ali Sahab, Professor of Law, Department of Professor of Law, Aligarh Muslim University, Aligarh, and Proctor of Aligarh Muslim University, Aligarh, for conducting a brainstorming and meaningful and fruitful session for the participants of NEP online program. I, on behalf of HRDC and on my personal behalf, I express thanks to you, sir. बहुत बहुत शुक्रिया सर, thank you.
Thank you, sir. Thank you.
Thank you so much, sir. Thank you.
Thank you. Thanks.
Thank you so much, sir.
Hello.
Okay, thank you.
Next session will be started from
Thank you so much, sir.
5:45. ठीक है और आज
Okay, sir. Thank you, sir. Thank you.